Welcome back, everybody, to the Law of Contracts. In this lesson, what we're going to do is carry on talking about the processes that can lead to a contract being brought to an end. In the previous lesson, we talked about the concept of mistake. And in this lesson, what we're going to do is talk about the concept of mistake as to quality, or mistake of quality specifically. So, this is the final type of common mistake that we can actually think about when looking at the concept of mistake within the law of contracts. In the last lesson, we talked about mistake as to the existence of the subject matter, as well as mistake as to the true owner of the subject matter. And we illustrated this with two pieces of case law, one being the idea of the creation of a contract for cargo which did not exist, since it had been sold by the person who had what was tasked with essentially transporting said cargo. We also talked about the concept of mistake as to subject matter, which was, of course, a contract which was created for the purpose of purchasing some particular property, some particular thing, but then it turned out later that that person actually already owned that particular piece of property, and so as a result of which there was mistake as to the true owner of the subject matter. This is the final type of mistake, and this is a concept of mistake which relates to the quality of the subject matter. Now, mistake of quality is and has historically not been considered a common mistake of such fundamental character, which would then, as a result of which, render a contract to be void. That's not historically how common mistake has essentially been operated. There are two main cases which illustrates this point quite clearly. The first is the case from 1932. This is the case of Bell versus Lever Brothers. In this case specifically, there was a defendant, of course, who had been one of the directors of a company. Now, before the expiry of this agreement, it was amended that the defendant leave early with the payment of £30,000 in compensation. The total compensation, in fact, was £30,000 and £20,000 to two different defendants. Some textbooks mistake this for £50,000 for one defendant. In fact, the textbook that, or at least a couple of the textbooks that I looked at, made this mistake. In reality, it was a compensation of £30,000 and £20,000 to two different defendants rather than £50,000 to one. Okay, simple as that. It later then transpired that the defendant had acted in a way which conflicted with the best interests of the company. They had violated one of the director's duties. Now, for those of you who would like to know more about the concept of director's duties, go over to our lessons on company law, where we have examined that in more detail. As a result of this, they did not require compensation in order for their contract to be terminated. So they terminated the contract with compensation, but then it later transpired that they had violated one of their director's duties, which meant that they did not actually need to give the compensation in order for the contract to get terminated. And then, as such, one of the things that happened was the company sought to recover that money on the basis that they were in fact mistaken in its payment. Of course, because they were mistaken as to the failure or the violation of the director's duty. The House of Lords, in fact, would reject this argument. And the reason why they rejected this argument was because they suggested that mistake was not, quote, of such a fundamental character as to constitute an underlying assumption without which the parties would not have made the contract they in fact had made. So, when we think about the mistake of quality as one of the common and mutual, or at least the common ideas of mistake, it is noted here that mistake of quality is not fundamental so as to constitute an underlying assumption without which the parties would not have made the contract in question. This is obviously unlike those other types of mistake where you would not have made a contract if you had known, for example, that the subject matter did not exist, or that you had already owned the subject matter. Those are instances of mistake as to the existence of the object and a mistake as to the owner of the object, and both of those involve a circumstance in which you would come to the conclusion that they would not have made the contract had they had known of that mistake. Another case to illustrate this point comes from 1950, and this is the case of Leaf versus International Galleries. This was a case in which a gallery, as you can probably imagine, had sold a painting under the assumption that the painting itself was a valuable piece. It was a valuable piece by Constable, apparently, according to the gallery's assumption. This, in fact, was a mistake. And it was in fact a mistake which was made by both the gallery as well as the purchaser. In fact, the painting was not a valuable piece by Constable. It was something else. And the problem here is, though, that the gallery had sold the painting under the assumption from both the gallery and the purchaser. They had sold the painting under the assumption that it was a very valuable piece of art, of classical art, which then meant that the painting was sold for a substantial amount of money. In fact, it was sold for far, far more money than it in fact was worth. And so when it came out and it was discovered that the painting in fact was not a Constable, and in fact was worth a far less amount of money than in fact it was sold for, the parties sought to have the contract voided on the basis of the fact that there was this common mistake, a mistake as to the quality of the product. Again, the courts rejected this view, and they argued that the contract itself was in fact valid. And what this does is speak to the argument presented by the courts that the concept of mistake as to quality is not so fundamental as to ultimately render a contract void on the basis of such common mistakes. So it is not so strong as the other kinds of mistakes, as I've illustrated a second ago, when we looked at the concept of mistake as to the existence of subject matter or the true owner of the subject matter. Finally then, let's talk about the case of Great Peace Shipping Limited versus Tavlaris, which is a word that I can't pronounce, as you know. This is a case from 2002, and it was a case in which it was held that common mistake is only valid, and it can only void a contract where there is an impossibility in relation to the performance of the contract, in addition to other fundamental factors regarding subject matter. This is quite interesting, because what this case specifically involved was a contract which had been made in relation to various different salvage services. Now, salvage is something that relates to maritime law, which we are not doing here. I'm sure we will do maritime law in the future, maybe one day. But fundamentally, what happened here is that the defendant had chartered a ship. The ship was the Great Peace. Falsely delivering the ship was only... falsely believing the ship was only 35 miles away from the salvage. In reality, the ship was in fact 410 miles away from the salvage, and as a result of that, the defendant cancelled their charter and contracted with another ship, which in fact was closer, and so could actually perform the salvage in a more reasonable time period. Part of the charter included a cancellation fee, and the defendant would have to pay compensation if they cancelled the charter. Makes sense. The defendant argued that there had in fact been a doctrine of common mistake applied, and so that the contract was void at common law. So there would not be the necessity to pay this cancellation fee because the contract was void. It never existed in the first place, fundamentally, at common law. And they sought to make this claim on the doctrine of common mistake because the ship was 410 miles away when he mistakenly believed it was in fact only 35. It was held, however, that there was no common mistake. And the reason for this is because when you talk about the concept of common mistake, it can only void a contract where there is an impossibility in relation to the performance of the contract itself. it was not impossible for the Great Peace to perform salvage services. They were 410 miles away, so the nature of the time period and the time frame in which this this operation would have taken place was vastly different to what the claimant had, or the defendant, should I say, believed it was. But in reality, the ship was not, it wasn't impossible for the ship to perform the services that they were contracted for. So you're mistaken as to the nature of the agreement, or to the location of the ship where it is, but you're not. The common mistake here doesn't render the contract impossible to perform. It only renders it a bit more difficult to perform, or not being able to perform in a certain time period. There was no specification in the contract as to how long it would take and how long it should take for the ship to go about its salvage services. So it wasn't impossible to perform the services that it in fact was chartered to perform. And so, as a result of which, the contract in question was in fact valid. And so, because the defendant cancelled the charter, there was a cancellation fee that the defendant would have to pay.